Is that new clause 8 be read a second time. Shadow Minister Seema Malhotra.
Thank you, Madam Deputy Speaker. It is a pleasure to follow the Minister and speak in the debate and to our amendments today. The Labour Party has supported this important bill's passage through the House and in a cross-party spirit through second reading and committee. And I pay particular tribute to the Right Honourable Members for Barking and Hodge Hill for their contributions through the course of our proceedings. The Minister himself, I may add my words of support, has had a long track record on these issues and a reputation through the APPG and other campaigns, which I hope bodes well for the further progress and amendments to the bill. However, it was frustrating, Madam Deputy Speaker, that during committee the government did not accept a number of amendments tabled by us and by other honourable and right honourable members that would have significantly strengthened the bill even further. The Minister did agree to keep some issues under review, which we will pick up on further today. Now, this long overdue second economic crime bill, Madam Deputy Speaker, is an opportunity to finally end Britain's role as a global hub for dirty money and to support honest businesses to trade and flourish with better standards and more transparency, helping level the playing field for businesses and cooperatives. I echo the Minister's words on the importance of this in tackling terrorism, economic crime and illicit finance and cleaning up our economy in the way that we all want to see. The amendments we have tabled are seeking to ensure that the bill goes further in areas including reporting and parliamentary scrutiny, strengthening the objectives of the Registrar to see a more proactive role in preventing and detecting economic crime, and tightening up the authorisation and supervision of corporate service providers. Other amendments now scheduled for tomorrow include amendments on the failure to prevent economic crime and director liability. I will give way.
There are many stakeholders that feel quite strongly that the bill and its powers require further development to be effective. Does the Shadow Minister agree with me that a statutory review process set out in the face of the bill is simply good practice and should be implemented?
Thank you. I thank the Honourable Lady for her comments. And I think what she is alluding to is part of the theme that we have going through the bill as well, which is that we can't expect this to suddenly be the answer to everything. We've got to keep this under review, and we've got to have the mechanisms for that review, which includes information and effective information coming through to Parliament. Now, Madam Deputy Speaker, the Minister has just spoken to the government's amendments. We are pleased to see some concessions, indeed, following committee stage. The government have tabled a raft of amendments, around 25, which remove powers to exempt directors from identity verification requirements. This is a huge concession by the government to a central question asked by us through committee about the completeness of the legislation, the extent of the Secretary of State's powers and the challenge required for parliamentary oversight. The extent of these powers had all the risks of riding a coach and horses through the defences against economic crime that we are seeking to build through this legislation. But even after these amendments, it still leaves a number of Henry VIII powers unchecked as well. And I'm sure that this will be a matter that will be continued in terms of debate in the other place. Now, the next welcome concession is the government's new Clause 15, which imposes a duty, Madam Deputy Speaker, on the Secretary of State to prepare and lay before Parliament reports about the implementation and operations of Parts 1 to 3 of the bill. This significant step, however, is surprisingly weak in setting any expectations of what Parliament would expect to see in the report. That is why new Clause 16 has been tabled with cross-party support by myself and the Honourable Member for Aberavon, and is similar to the amendments tabled by colleagues during committee. With our amendment, the purpose for the report, I believe, is clearer and stronger. An annual report with an assessment as to whether the powers available to the Secretary of State and the Registrar are sufficient to enable the Registrar to achieve her objectives under Section 108(1)(a) of the Companies Act 2006, which is inserted by Section 1 of this Act. I will briefly give way.
She's making an excellent speech and trying to push for even better legislation. Would she agree with me that this particular aspect of the debate would lead to a change in culture, which is what we really need to see, so that this annual reporting system would just lift the game and increase and improve the actual culture of the way that business is done in this regard?
I thank my honourable friend for her intervention. I think she is absolutely right, and I think it would do two things. It wouldn't just change the culture of how Parliament operates and how it expects to operate and play a role in tackling economic crime, but it would also shift the culture and based on our expectations of business and how business should behave and how directors should be held to account, and also shift the culture within Companies House and the work of the registrar. For all those reasons, I think it is a very important area for development. But let me just return to the amendment, the new clause 16 that we have tabled. I will very briefly take.
My colleague's making a brilliant speech, but would she agree that it's vitally important that we have got a much more wide-ranging report on the nature of economic crime, because we know that there are 10 different agencies that are responsible for policing economic crime, and indeed we learned in report stage that many of the provisions in the bill would not have stopped, for example, individuals like Alisher Usmanov buying himself a multi-million-pound London mansion, only to then be sanctioned a little bit later on. These are exactly the kind of crimes that we do need bringing to the House's attention, so that we can ensure that we keep this economic crime legislation up to date and don't have to wait for 170-year cycles before we make substantial reform.
Seema Malhotra.
My honourable friend is absolutely right in his intervention about keeping our legislation up to date. And he says that with great authority, also recognising that those who seek to perpetuate economic crime are always innovating. And unless we are aware and informed, we will not move our legislation and our processes on with that. But there is also a vital point about the information that does come to this House. And what we're debating today is about the reporting and the information that comes. There'll be some further debate tomorrow, which is about the appropriateness of structures through which that information is also assessed. But this new clause that we have tabled seeks to further specify some of the information that should be brought forward, and also, I think very crucially, also calls for a detailing of instances, which may even be numbers, depending on the reasons for this, but the instances in which exemption powers have been used by the Secretary of State that may be used under this Act. And the Minister will be aware of the concerns that we raised through committee about the transparency even on the number of uses of exemption powers under this bill, and the need for there to be transparency about that to Parliament. I will very briefly give way.
I thank my honourable friend, and she's making an excellent contribution to the debate. I think the point about this is that the government's amendment simply reflects reporting on the process of implementation. Well, that's how I read it, and that's how he spoke to it. And if I'm wrong, I'm happy to be corrected on that matter. What we're trying to do in the amendment that my honourable friend on the front bench is speaking to is ensure that we have a view, we can hold to account the whole works of the Companies House to ensure that it delivers what we have in mind in terms of being at the front edge of fighting economic crime through the data that they collect there.
Yeah.
I thank my right honourable friend for her intervention, and she is absolutely right. And in fact, we should be ambitious for the Registrar and for Companies House in tackling economic crime and being a beacon around the world for how a nation should do that. And she is making a very important point, which is about where our amendment goes further, which is to, along with the report and the data in it, to very importantly have recommendations as to whether further legislation should be brought forward in response to the reports, to the report and the information in it. And this is extremely important because that is where Parliament will have to make choices about whether it chooses to take further action. But issues of a concern that it may also draw attention to and which we can encourage the registrar to be looking at could also include investigations of unusual patterns of directorships and companies registered at one address and with all of this enabling Parliament to hold companies' house to account as well for its performance. Now, we are willing to work with the Minister to strengthen the government's amendment as tabled so that it becomes more purposeful and effective, and I think in doing so to achieve the outcomes that we intend from this legislation and do so collectively. Now I turn to further amendments tabled by the Labour front bench. New clause 22 seeks to disqualify any individual convicted of an offence for a serious breach of the National Minimum Wage Act 1998. Such as a deliberate refusal to pay the national minimum wage and prevent such an individual from serving as a company director in future. Now, during committee stage, the Minister stated that it is right to identify the scale and the nature of the problem before we legislate, and that he was keen to do so. He said, Mr Deputy Speaker, that there have been 16 people convicted under the National Minimum Wage Act 2008, and I want to do some further research on that to see what has happened to those people and their director disqualification and their director qualification or disqualification. That might inform the debate more clearly. Now, since then, we haven't heard a satisfactory answer to the central question. Should an individual convicted of an offence for a serious breach of the National Minimum Wage Act 1998, such as a deliberate refusal to pay the national minimum wage, be prevented from serving as a company director? This new clause... I will give way.
The Shadow Minister giving way. I mean, isn't the point that if someone is convicted of a criminal offence, the court automatically has the power to disqualify, and therefore by not being very prescriptive in the Act, the judge on a particular case would have more leeway than perhaps the Honourable Lady would be giving him through the Act?
I thank the Honourable Member for his intervention. I think he is perhaps missing some of the argument that we were making around this central question, and it doesn't happen in all cases. But in relation to the work that the Minister started, the research he started during committee, and in relation to his commitment to follow up on that and look to what happens with those directors, we haven't received any further information. And in our view, this new clause would strengthen the bill because we are talking about people we hope to have trust in to undertake their responsibilities as a director. And this bill introduces a substantial amount of regulation about who can and who cannot serve as a company director as a result of criminal or potentially criminal practices. So this does feel like the right place for consideration of such a measure, and I would be grateful for the Minister's response on this. I will say that subject to the Minister's response, we may well be pushing this to a vote today, and I'm happy to give him forewarning of that. Our new clause 24 calls for a creditor or liquidator to be able to apply to restore a company to the register administratively. Currently, Mr Deputy Speaker, if former creditors or liquidators wish to apply to restore a company, it is through the court, and often a complex and costly procedure. It may well take 12 to 18 months or longer. Now, the Minister said in committee stage that there ought to be a basis for a less cumbersome process for creditors and liquidators, and particularly liquidators. We agree with him. And currently, when companies are struck off the register, which is on average around 400,000 companies a year, very little is done to check whether fraud has occurred. As a side issue, the Minister may helpfully confirm whether or not directors who have companies that have been struck off will also be subject to verification checks, so that we don't have a period through which they may escape verification, ID verification, as Companies House looks to undergo those checks with existing directors. The key issue is that unscrupulous directors can misappropriate the strike-off process to avoid scrutiny and to rack up debts or sell company assets ahead of the company dissolution, absconding with the proceeds. The Minister said that he appreciated the case for widening access to the less cumbersome process of administrative restoration, and he undertook to consider the matter further. If he doesn't agree to our amendment, I would be grateful if the Minister would commit to bringing forward proposals from the Government to do so during the passage of this bill. This is a window of opportunity that we should not miss. I now speak to new clause 34. Now, in terms of the processes that we are giving effect to through this legislation, it relies on effective ID verification of company directors. And there has been a debate about whether that should be done in-house. The government has chosen to use a model whereby authorised corporate service providers are trusted to undertake ID verification on behalf of Companies House and effectively certify that through a confirmation statement. That debate is ongoing about how that introduces risk into the process. And indeed, if the registrar can only do part of the verification and we need to use authorised corporate service providers, this only works if those ACSPs are known, are trusted and are effectively regulated. Now, this amendment seeks transparency reporting on the involvement of foreign corporate service providers through two main routes through which they may be authorised to conduct ID checks and to incorporate a company in the UK which is registered with Companies House. Such a company being registered could have an office address in the UK, a postal address in the UK with all the risks that we have debated in committee, or an address abroad as an overseas company. The directors of that company registered under Companies House by the foreign corporate service provider may be living abroad and may never come to the UK. This amendment would seek to create an obligation for the Secretary of State to publish a report, firstly into the number of authorised corporate service providers with a head office based outside of the UK. By this we mean where the authorised UK subsidiary, which is supervised by HMRC, is beneficially owned by a company that is outside the UK. Secondly, a report on the number of foreign corporate service providers authorised by regulations set out in the new section 1098I Part 1 of the Companies Act 2006, which is amended by Clause 63 of the Bill. Now, Clause 63 enables the Secretary of State by regulations to authorise a person abroad to become a foreign authorised corporate service provider, even if the person is not a relevant person as defined by Regulation 8 Part 1 of the money laundering regulations, i.e. a lawyer or art dealer, for example. They are therefore not supervised. Subsection 2 of that same part specifies that confirming a relevant regulatory regime means a regime in the opinion of the Secretary of State that has similar objectives to the regime under the money laundering regulations. However, it does not specify for any transparency over how that conclusion is reached. This clause is a risk for a backdoor route for the authorisation of foreign corporate service providers. It is a risk for a backdoor, with the Minister shaking his head, I'm going to repeat it, for a backdoor route to the authorisation of foreign corporate service providers in a high-risk territory who fall outside money laundering regulations. I'll just complete my comment and I'll bring the Minister in if he wishes to. So I would be grateful for the Minister if he could confirm, when he speaks, why this is in the legislation at all in this way, and the extent of the safeguards intended to be in place. He will, I am sure, be mindful of the need for trust and confidence and to have transparency over who our corporate service providers are, and who they are undertaking ID verifications for, which we are then expected to trust. And subject to the Minister's response, we do intend to push this transparency reporting amendment to a vote. If the Minister wishes to come in now, I'm happy to take his intervention.
I'm very grateful. It is not a backdoor to try and get around the legislation. I can't think why she would think we would write 309 pages of legislation and then create a purposeful backdoor. The reason for this, potentially, is you can imagine something like an international trade agreement, free trade agreement, not with a high-risk jurisdiction. Why would we do that? But where the international partner had an anti-money laundering regime that we felt was equivalent to our own, it might be something we would consider in that context, but in no way, shape or form is it some way to create that kind of backdoor. And it is the kind of thing that we would very much expect to be reported in the annual report that we would get, that Parliament would receive in terms of the implementation and the operation of this legislation.
Thank you, Mr Deputy Speaker. And I'm grateful to the Minister for his intervention and for his context within which the government is introducing this clause and their intentions for this. I do think, however, that there is a difference between intention and how the clause could be used. And I do think it is worth the government taking some further legal advice to look at how this clause could be used, because legislation isn't just about how ministers today might intend to use it, it is about how the legislation and powers could be used tomorrow. And with the succession of Secretaries of State that we have had, some of whom perhaps maybe, how should I put this, I shan't go any further because I think the House will understand those that have been in this position and whose judgment may be questioned a little more than others in their position in this House. And it is important that legislation isn't about what might be intended, but it is about what could be done. And the powers that could be used by Secretary of State in the future without the accountability to this House that would be required. And the wording in the opinion of the Secretary of State, the lack of clarity over how that conclusion might be reached, the fact that under this, as I have talked to lawyers, under this legislation you could have this mechanism being used to create an agreement with a high-risk jurisdiction. It doesn't specify it's under future free trade agreements, and I would encourage the Minister to just look again at whether it should be tightened in terms of how this clause is being implemented. Now, turning to the role of the Registrar, Amendment 104 inserts a fifth objective into Clause 1, requiring the Registrar to act proactively. This amendment reflects concerns heard during our evidence sessions that the objectives in Clause 1 of the bill seem like a ridiculously low bar. It would take the objectives from being about minimising risk to being about proactively seeking to identify suspect users of the register for criminal purposes and acting accordingly. This is also a strong enabler of the risk assessment-based approaches to detecting and preventing economic crime, which is suggested through further very important amendments tabled by the Honourable Member for Barrow and Furness and the Right Honourable Member for Barking, amongst others. These
Member give way.
I will give way.
Does she not agree with me that there's absolutely no objection to this, that the Minister in his opening remarks has said that he sees it as a proactive, that the reforms will change Companies House into a much more proactive capability? And therefore, if he sees that and we want that, what on earth is the objection to putting it in legislation so that they know darn well that that's what we expect of them?
I thank my right honourable friend for her intervention, and I think the Minister has heard what she has said, and indeed, if this is what Parliament would wish and intend, we should have the courage to put it on the face of the bill. And in terms of amendments that she has tabled, and the Honourable Member for Barrow-in-Furness and others, they are important amendments, and we do support what they are calling for. And these include new Clause 17, new Clause 19, Amendments 102 and 103, and we strongly support and separately also encourage the Minister to look at Amendment 101.
Would she take a brief intervention?
I will take a
It's
very
extremely brief. I thank the Shadow Minister for that. And does she believe that within the debate this afternoon we've covered off the important area of Phoenix companies and protecting the consumer? Because clearly there's a role there for the registrar in terms of detecting fraud and ongoing recidivism within that.
I thank the honourable, my honourable friend for her intervention, and indeed that is part of what we are looking to do. There is further to go in that, and I know that other amendments that have also been tabled by other colleagues also draw on the issue of phoenixing and the importance of us preventing that. And indeed, the checks on companies that have been struck, directors of companies that have been struck off, and the ease of administrative restoration are all parts of tools that we could deploy to help tackle phoenixing and protect customers as well as other businesses and creditors too. Let me speak now to Amendments 105 and 106, which draw on the wider theme of duties, not powers, in this bill. We want to see a clear outcomes focus and to legislate for things to be done, not to legislate for the potential for the registrar to do things. That's a very, very important distinction. Our amendments state that, firstly, it should be a duty and not a power for the registrar to allocate a unique identifier to a director. Secondly, that the registrar should ensure the use of the same unique identifier on any other entries the person has on the register, whether under the same name or a different name. Thirdly, through Amendment 108, we want to reduce the risk to the integrity of the register through a tightening up of the confirmation statement. A proposed director must confirm in writing whether they, A, already have a unique director ID with the register under a same or a different name, and if so, what it is, or B, that they do not yet have a unique ID. If an individual chooses to go by a different name, or may have dual citizenship and use a different passport for ID, or may even have a fake birth certificate suggesting a different date of birth, how will the registrar know? It is a protection for the system if subsequently an individual is found to have lied about their identity. And I suspect that broadly we are in the same place in what is intended to happen through this legislation. So it would be helpful as well if the Minister could confirm the following. Would the Minister be expecting the registrar, under the arrangements he has put forward, to issue a unique ID to each director, new director, and to existing directors on the database? And should we interpret, for all intents and purposes, that the power will operate in practical terms as if it was a duty? The second question is if, in searching on the Companies House website, if in clicking on a director's name, should that then bring up all their directorships, which are linked internally by that unique ID, even if they go by different names in different companies? Perhaps the Minister wants to just intervene on those 2 points now.
Work.
Well, I thank the Minister for his confirmation. I think if the legislation isn't as tight as we would like, but he is going to put on record his intentions, then that does take us a step further. Let me speak briefly now also to Amendment 107, which would require that a limited partnership dissolution notice be published on the registrar's website and remain published for a minimum of 20 years. Previously, the Minister said he would like to explore with Companies House the feasibility and costs associated with introducing this requirement. I would be grateful if the Minister could confirm whether he's concluded these discussions and what position he has reached on this. Now, new Clause 20, which we support, is about resourcing. This would raise Companies House fees to £100 to help properly fund the fight against economic crime. The current fee, at just £12, makes us the 6th cheapest place in the world to set up a company. The Treasury Select Committee recommended a fee of £100. Could the Minister tell us what his plans are? Having a plan to resource Companies House is utterly fundamental to achieving the goals of this bill. I also want to separately thank the SNP for their amendments, which support similar arguments to us, and in particular to mention new clauses, new clause 36 and Amendment 109 on reporting and unique IDs. Whilst there are some minor changes we think we might have made to new clause 36, we do support both, and we would support any if they push them to a vote. Now, finally, on new clause 26, which has been debated today but would be up for decision tomorrow. This would amend the wording of provisions in the Sanctions and Anti-Money Laundering Act 2008 to require the introduction of open registers of beneficial ownership in each of the UK's overseas territories. There should be no double standards in the legal requirements for transparency of beneficial ownership across different parts of the UK, including in the overseas territories. We have simply witnessed too many scandals involving money being laundered through territories for whose administration the UK is ultimately responsible to accept the idea that we must simply leave it to them and leave it to their own devices. According to the spin the government chose to put on the wording of the 2018 Act, its obligation had been met simply by the publication of a draft order in Council, regardless of when or even whether such an order might actually come into force. The result is that here we are yet again, almost 5 years later, still discussing how to ensure the implementation of registers to the same standard across all of the UK's territories. Surely it should not be beyond the wit of ministers, even in this government, Mr Deputy Speaker, to have sorted this out by now, with the exception of the Minister here today.
Will my honourable friend give way on that point?
I will give way.
She is raising a really important point that has been put into some question by a judgment of the European Court for Justice in relation to action brought of a shell company in Luxembourg. It is a really important point that I know is not entirely in the Minister's control, but what is particularly important is that the Crown dependencies are agreed in 2018-19, whenever it was, in 2018, to actually also publish registers of beneficial ownership. And we never passed legislation because we got their agreement verbally. And I am really concerned that they will go back on that now in the light of the judgment, and would be really interested to hear what the Minister's views on that are.
I thank my right honourable friend for that intervention, and indeed the discussions that we have had on this matter prior to report stage. In summary, Mr Deputy Speaker, this legislation is essential. But as we have heard from across the House today, there are still areas in which it must go further if we are to catch up after years of being on the back foot on economic crime due to years of inaction. These are thoughtful and purposeful amendments and will improve the bill, and I look forward to the Minister's response. Thank you.
Harriet Baldwin.
Thank you very much, Mr Deputy Speaker, and I rise to